Greetings, gentlemen. This is yet another piece of fantastic XRP news that I have for you today. Take a look at this news. John Deaton, an attorney for XRP, is contesting the chair of the SEC regarding the selling of XRP. As someone who is in favor of cryptocurrencies, John Deaton has voiced his disagreement of the position that Jay Clayton, who was once the chair of the Securities and Exchange Commission, has adopted regarding the programmatic sales ruling for XRP. In response to Clayton's comparison of the XRP issue with other issues involving the Securities and Exchange Commission, Deaton argues that the Ripple scenario is fundamentally different from the situations that other companies are facing. The recent comments made by Jay Clayton, who is a former head of the Securities and Exchange Commission, addressing the programmatic sales ruling that applies to XRP, have been met with widespread condemnation by John Deaton, who is a notable advocate for cryptocurrencies. Deaton has made his disdain known to the public, with a specific emphasis on the complications of XRP classification and the regulatory repercussions of that classification. This new revelation adds another degree of complexity to the already complicated legal dispute that Ripple and the SEC are engaged in. According to Deaton, who has been a big booster of Ripple and the cryptocurrency XRP that is linked with it, Deaton offers Clayton as an example in response to Clayton's analogy of the XRP scenario. Clayton's remarks concerning the SEC's legal stance on XRP were met with a response from Deaton, who indicated that he is, as is his customary practice, misrepresenting the truth. In particular, Deaton addressed the issue of XRP secondary trading. Clayton had made analogies between the case of XRP and other legal difficulties that were comparable to those that the Service Commission of Canada had been experiencing. During the phase of capital raising, the court rendered a ruling that is consistent with other cases in which the SEC has emerged victorious. This decision pertains to the initial issuance of XRP as a securities transaction. Deaton, on the other hand, provided a response to Clayton's parallel by studying the Ripple incident and identifying the peculiarities that set it apart from comparable situations. He brought to Deaton's attention the significant differences that exist between the litigation concerning XRP and other cases, such as those involving Terraform. At the same time, he attacked Clayton's stance, claiming that it was an oversimplification and that it failed to fully depict the nuances of the XRP legal dispute. He said this while he was arguing that Clayton's viewpoint was problematic. Legal success for Ripple and the ramifications of this victory. This debate focused on Ripple's recent legal victory, in which Judge Analisa Torres concluded that the automated sales of XRP tokens on secondary trading platforms did not meet the standards of a security sale. This result may have repercussions for Ripple in the future. This choice is at the heart of the disagreement that has arisen. Regarding the method in which digital assets are governed and classed, it is probable that this decision will create a precedent for the future. Within the context of the SEC Ripple case, this ruling represents a pivotal point. After the verdict was announced, Clayton made some remarks in which he hinted that secondary trading of XRP could still be regarded as securities transaction. He made these remarks after the verdict was announced. Taking into consideration the specific circumstances and evidence that were presented in the Ripple prosecution, this position does not take into account the particulars of the situation. The response that was offered by Deaton sheds insight on the ongoing debate that is taking place within the cryptocurrency community over the regulatory approach that the SEC takes toward cryptocurrencies, in particular XRP, for the most part. Garlinghouse has expressed his appreciation to the XRP army for their support during the ongoing legal issues. Ripple and Garlinghouse are victorious in a huge judicial battle and are found not guilty of any claims regarding their actions. Garlinghouse recognizes that the support of XRP army is necessary for Ripple to navigate its way through the legal system. Ripple's Chief Executive Officer, Brad Garlinghouse, recently delivered a speech in which he expressed his gratitude to the XRP army for their unwavering support of the company during its legal issues. Garlinghouse's comment was made in the context of a recent speech following the inclusion of Garlinghouse on the list of the most significant people in the digital assets and Web3 industry for 2023. This recognition has come about as a result of the inclusion of Garlinghouse. Ripple has achieved a number of significant milestones in the year 2023, one of which is a significant court victory over the United States Securities and Exchange Commission. This victory is only one of the many noteworthy events that have taken place during this year. Ripple, a blockchain-based payment platform and cryptocurrency issuer has reached a significant legal milestone in the year 2023. This milestone was attained as a result of Ripple's court triumph and the clarity of new legislation. The United States Securities and Exchange Commission, which has been conducting a comprehensive investigation of Ripple's XRP cryptocurrency for the goal of finding whether or not it breached securities laws, was defeated by the company in a crucial legal struggle. The inquiry was conducted with the intention of determining whether or not the cryptocurrency violated securities laws. Because of this victory, which resulted in the establishment of regulatory clarity for XRP, Ripple, and the cryptocurrency industry as a whole experienced a critical turning point. This victory brought about the establishment of regulatory certainty. An interlocutory appeal request that was filed by the Securities and Exchange Commission was dismissed as a consequence of a judicial victory, which led to the reaffirmation of the view that XRP should not be classified as a security. As a consequence of this judgment, Ripple's position has been strengthened, and the XRP community and the cryptocurrency market as a whole have experienced a sense of comfort as a result of this decision. To add insult to injury, the Securities and Exchange Commission is currently investigating all of the charges that have been made against Chris Larsen, who is the co-founder of Ripple, and Brad Garlinghouse, who is the CEO of Ripple. Earlier claims had been made against both of them, stating that they had aided and abetted Ripple, as well as violated several regulations pertaining to securities. The community of Ripple has expressed feelings of relief in response to this new development, which has also served to underline the company's commitment to innovation within the cryptocurrency market on a worldwide scale. Ripple's journey through the legal obstacles and regulatory scrutiny that it has encountered is illustrative of the resilience of the cryptocurrency industry as a whole, as well as the capacity of Ripple to endure hardship. Additionally, it represents the resilience and adaptability of the cryptocurrency business. Despite the fact that it has been facing regulatory headwinds and legal obstacles, Ripple has continued to thrive and innovate despite these challenges. The resilience of the business has not only been advantageous to the firm, but it has also demonstrated the increasing maturity of the blockchain and cryptocurrency ecosystem as a whole. It was led by notable persons such as John Deck, and one of the members of this community is known as the XRP Army. They provided a novel perspective on the consequences that the actions made by the SEC will have on investors as individuals, as well as the larger XRP ecosystem, by submitting an amicus brief. This was done in order to provide a fresh perspective. Garlinghouse's acknowledgement of our efforts and effort. Brad Garlinghouse recently delivered a speech at the Hammerstein Ballroom, during which he reflected on the challenging period that occurred in December 2020, when the lawsuit filed by the SEC cast a shadow of uncertainty over Ripple and XRP trading. During his address, he reminisced on the difficult time period that occurred. In the midst of this difficult time, Garlinghouse stressed the role that John Deaton and other members of the community performed as guiding beacons of positivity. Garlinghouse said that they were positive influences. Both Ripple's legal victories and the preservation of XRP's status as a cryptocurrency were immensely aided by their unwavering support and activism, which played a vitally crucial role. Both of these accomplishments were made possible by their unwavering loyalty. That's all for now.